I thank you and all the witnesses for being here and testifying for the committee. Some with some personal difficulty, but I appreciate your willingness to come forth and put color on this issue. It's truly sad that we have to even have a hearing. Arbitration is an issue that has come before this committee in other instances, and I'm against forced arbitration, but I can understand it in certain issues. But when you have forced arbitration, where you have to deal with forced actions by your employer on you, and then you have forced arbitration, that's what they call a hat on a hat. You don't do a hat on a hat. It's doubly bad. So I appreciate your being here. Today's witnesses and countless others have been sexually harassed or violated by people who thought they could get away with it because they were the boss. The boss gets whatever the boss wants. And especially if they have forced arbitration, they know about it. Sometimes you don't, because you don't get into the contract. You want the job. You don't get into the nitty-gritty and the details and understand it. And you have no choice. It's an adhesion contract. You get the job or you don't. So you take it and you expect you're not going to have that kind of conduct anyway, so it's no big deal. But then you have the conduct. They know they've got the forced arbitration. And so they feel comfortable harassing you because they know that they've got this forced arbitration and they're going to come out the winner. They got the deck is stacked in their favor. Professor, is it Giles? Gillis? Gillis, okay. The structure of forced arbitration allows perpetrators to operate this way. Could you walk through the preliminary difference between the traditional legal system? You might have already done this while I was under my hood, and forced arbitration.
I'm sorry, I didn't hear the question, sorry.
I say, the primary difference between the traditional legal system?
Oh, I see. Yeah, totally fine. So in a traditional legal system, I go to court and I file a complaint, which is immediately publicly docketed, meaning I can search for it. It is a public document that other people in my workplace can read and learn about the allegations that I've made against an attacker, a perpetrator, or the employer. All subsequent briefings and other filings are publicly docketed. The hearings before the court are, the public is welcome. The press is welcome. And that kind of transparency, I think Eliza called it, sunshine is the best disinfectant. I think that's what our legal system is based on. We don't have many closed-door judicial proceedings because we believe that the best way to get justice is to make sure that everybody is watching. And I think in this space in particular, people have to be watching. Employers have to know that there will be consequences if they don't deal with toxic corporate culture.
And in forced arbitration, it's not necessarily in the open. It's private.
It's private.
Kept under covers.
Right. Yep.
Protects the violator.
No written decisions. Arbitrators are not able to offer relief beyond, to deal with structural or pervasive problems.
How has this structure impacted the success or lack of success of claims brought by victims of sexual assault?
Well, first of all, the structure almost guarantees that very few victims will ever come forward. I think we're seeing a few very, very brave women who are able to come forward and go through arbitration, but because you have to arbitrate individually and because you have to play by the rules that the employer has written, lots of people feel like the game is rigged before they even start.
Right. Who picks the arbitrator? I mean, are the arbitrators generally folks that have a record of being favorable toward business employers?
Well, so, just to disaggregate the question a little bit, the employer pre-designates the arbitration provider, say the American Association of Arbitration or JAMS or some other group, and then the entities may pick the arbitrator. But here's the problem. If I'm an individual employee trying to arbitrate against my employer, I don't know who those arbitrators are. I get a list of names. I don't know who they are. Whereas the employer definitely knows who they are because they are repeat players in the system.
Somehow it works out, according to my information, that in the last 5 years, only 1.9% of victims have won their arbitration cases against their employer.
Yes.
That's worse than Congress getting its subpoenas enforced against the Trump administration. It's bad numbers. It's just amazing to me that we even have to have this hearing, that it shouldn't be permitted, and in these type of cases, because the person uses their power to try to bring pressure to get sexually harassed or sexually assault, and then they get to have a system that's in their favor where it's a 50-to-1 shot to win. It's absurd. Thank you all for testifying. I appreciate it. I yield back the balance of my time.